Uh, Welcome everyone. I hope that we will get some more people, but having a webinar on the hottest day of the year isn't the most clever thing to do. But welcome, and I'm sure we're going to have a really, really useful session for the next hour, which may take us away from any feeling of and housekeeping. Please turn your phones off if you're chairing. Thank you. So welcome, anyway, to a webinar on M&A and the intersection with investment disputes, particularly investor-state dispute settlement. And it's my pleasure to moderate today. And I have the enormous pleasure in introducing you to our speaker, Hafsa Zayyan, who is a partner at the law firm Quinn Emanuel. She's had a spectacular rise, I think, into her present position. She did her first degree at Cambridge, which was brilliant. And then she did a BCL at Oxford, which again was similarly incredibly distinctive. She then did a period of training at Herbert Smith for a number of years, and then moved as an associate to Quinn Emanuel just about 10 years ago. And in the time that she's been at Quinn Emanuel as an associate, she has rocketed to the position of being the youngest partner appointed at Quinn Emanuel in 2025. And that indicates, I think, the unbelievable qualities that she has in relation to the area of law that she's chosen to deal with, which is basically M&A and international arbitration law. The website tells me that she was ranked as one of the next generation partners by Legal 500, which is one of the main organizational groups for ranking lawyers. And law.com in 2024 said that she was a rising star and one of the best top lawyers under 40. Quinn Emanuel, of course, is well known as a global firm attracting all the best talent. And I note from their website that they use a quote that they are the law firm most feared globally by large businesses. So the sort of sharks that they have as partners are I hope not necessarily best exemplified by Hafsa, but certainly the work that she does is of the highest caliber. She focuses on international arbitration and cross-border complex litigation, and has represented clients and arbitrations in all the major centers and under all the major rules. It's said that she often has a civil fraud asset tracing angle, but most of it's multi-jurisdictional, and we know how complex that can be, particularly in the world of M&A and international arbitration. Although she has a particular experience in Africa, the CIS, and the Middle East. And there is a very impressive list of notable representations that she has been in recently. What I would like to do, her webinar today is entitled From Term Sheet to Tribunal, Exploring the Intersection Between M&A and Investment Disputes. And I think she is admirably qualified to talk to us about that today. We had thought that we will try and have a sort of dialogue approach to the webinar today as much as we can, although it will be very much a tyro talking to someone extremely experienced. And so what I'd like to ask first of all from Hafsa is, assuming that the seminar is coming out of your practice, could you give us a little more detail than that I've managed to glean from the website about the sort of cases that you deal with and the sort of issues relating to the topic that have arisen, and then we can sort of move on from there, I think, to look at the different intersections that come into play.
Sure. Thank you so much, Ian, for that very kind and generous introduction. I'm not sure I am as established as you have made out, but I appreciate that all the accolades do stack up in the end. So thank you very much for that. In terms of what I do, I think that the reason that I found this topic so appealing to talk about today, I have quite a lot of post-M&A experience in general commercial contexts. So you have a sort of standard deferred consideration and earn-out type of disputes, but also, post-M&A misrep claims, fraud claims, buyer's remorse type claims, and I sort of have litigated across the whole spectrum of the post-M&A experience. One of the things that I've done in particular is post-M&A arising out of dispositions, acquisitions in Africa. As Ian mentioned, I've done quite a lot of work in sub-Saharan Africa in particular. I've had a natural interest in it. And the sort of multi-million and sometimes billion-dollar disputes that come out of the sort of post-M&A disputes I have been involved in. I also do investment treaty arbitration. My investment treaty work has been mainly representing states. I've represented investors too, though, and it kind of takes one to know one, so it's always good to be on both sides of the dispute and seen both sides of the dispute. Sorry, I think there's some feedback coming from my WhatsApp, so I'll just quickly switch that off. I keep hearing all these clicks. Sorry, just get rid of that. Apologies. So I think what I was saying is that I do investment treaty arbitration and then post M&A experience as well, and the sort of merger of those two topics is something that's always been of a lot of interest to me. So in the context of the representations that I've done in an investment treaty context, there have been issues that have arisen in connection with the transfer of assets. And I've also advised on the specific issue of the assignment of claims, which is slightly further away from strict M&A speaking. But I think basically what we're going to talk about today covers the whole sort of spectrum of how you monetize potential claims, and also what happens and how can you benefit from treaty protection in the context of M&A. So I think that's probably enough for that first question.
No. Well, that indicates really the massive wealth of both your experience and also the way in which M&A is developing and moving away, as you say, from the ordinary post M&A disputes that people are used to, the shareholder claims, the counterparty claims, which are looking at issues of interpretation of the M&A documentation. To wider considerations, and this I think is one of the intersections that is coming to the fore. The fact that the M&A disputes used to be very much domestically related, but now often because of the cross-border nature of the M&A and the fact that you've got a lot of international parties being involved, it's moving it away from what used to be a very sort of cozy domestic dispute sort of area. Would you agree with that?
Yeah, I absolutely would. I mean, and you can just sort of see the increase in the number of investment treaty claims since its original sort of inception. I think there's sort of the doctrinal development of the law in and of itself, but also user sophistication, like you say. So I think, we've got all of these new sort of structures, third-party funding. There's an understanding of corporate restructuring to obtain treaty protection, and the sort of general kind of evolution of treaties. And like I said, the sort of way in which we've developed the doctrine of what you can and can't claim for. So I think also, like you say, we're not sort of talking about bricks and mortar type projects anymore. We're talking about more kind of complex financial assets, sovereign bonds. You might have financial lenders qualifying as investors. And of course, with ISDS, you have your shareholders as well. So you have your shareholder claims, and sometimes these shareholders are almost passive investors who are just holding stock as a sort of means to diversify their portfolio. So I think generally speaking, the kind of growth of capital markets and the proliferation of alternative financing, hedge funds, pension funds, just all of this sort of increases the diversity of potential claimants. So sorry, I think that was me again. These things popping up. But yeah, I think both the nature and the types of investors have become more fluid, and all of this is right for the continued development of this body of law, which is obviously something that we all take an interest in.
So it's really the interesting area is the cross-border one, the one where you're dealing with the intersection of foreign direct investment within a state, which has M&A aspects to it in terms of buying and selling or acquisition of companies or shares or things like that. Now, a lot of that will be different from ordinary basic M&A, because you'll be involving often state organizations and states, I think, won't you? And how does that affect the way in which M&A disputes in this particular field are organized? You mentioned that there may be in provisions in relation to state screening and I think state blocking. But what sort of issues arise out of the fact that you've got a state involved in these issues rather than just two business partners or two business operations?
It's an interesting question, Ian, because M&A and ISDS are not necessarily, it doesn't necessarily need to involve the state. So you don't necessarily need to be purchasing an asset from a state, or you don't necessarily need to have direct state involvement in the actual M&A itself. You can have a private M&A that's a cross-border M&A. It's a form of FDI. You acquire something from somebody who is not even necessarily based in country, but has an investment in country. So you make that acquisition, or there's a merger, or there's a corporate restructuring, or something's happening where the asset that's held in country changes ownership. And the interaction with the state and the sort of level at which kind of state gets involved, I would say it's sort of threefold. So these are typical sources of where can I get treaty protection. And the first is, investment treaty, of course. If you're a national of a state which has an investment treaty with the host state that you are acquiring an asset in, of course, you might have a potential, you might qualify potentially under that treaty, depending on if you meet all of the other jurisdictional hurdles. The second is local laws. So, foreign investment laws, which provide for ISDS in the case of, for example, Venezuela. We know that there was a lot of litigation arising out of Venezuela's foreign investment law. And then the third place, of course, is the contract. So the entity that you're acquiring may have a contract with the state, and there might be an ISDS provision in there. So in that regard, cross-border private M&A actually interacts with investment treaty or potential investment treaty or sovereign dispute issues without necessarily having to deal directly with the state. But you mentioned FDI and FDI screening. Now that's a slightly separate issue. So with FDI screening, we've got this sort of trend now of states adopting these laws that are aimed at sort of screening foreign direct investment, which might impinge, for example, on national security or strategic interests. I think this is a really interesting.
I just want to give you an example, like the UK National Security and Investment Act 2021.
Yeah, absolutely. Absolutely. And that's a good one to mention, because the UK has now issued its first ever divestment order in respect of an acquisition that was made by a Luxembourg company, which ultimately was owned by sanctioned Russian individuals. So they've actually now made a divestment order in respect of that. I think it's been appealed. It's been challenged in the High Court and then appealed, and it's being appealed up to the Supreme Court as well. But it's a very pertinent point and a good one. I think countries all over the world are enacting these legislation which aims to sort of protect their national security or strategic interests. Now, I think this is something that's going to become very important and is going to grow in importance as the sort of geopolitical arena develops in the way that it's developing at the moment. Because I think one of the things that we're all wondering is how much of these rules are driven by sort of geopolitical alignment as opposed to direct economic, interests or directly security interests. But I think what's really interesting about this sort of FDI sort of screening is how it interacts with ISDS, because when you've got these investment treaties, there's sort of types of treaties or models of treaties, and some treaties, which is sort of in the earlier generation, they don't provide at all for an investor to have a right to establish themselves in the country. So if you've got an FDI block, you've got an FDI screening, or you get a divestment order, I suppose, is slightly different because it's almost retroactive in a way. You've already made the acquisition and then you're being asked to divest it. But if you have a block, if you have the state saying, okay, you can't enter, if you are a national of a country of that first sort of generation of early kind of investment treaties, you are looking at not having any right under the treaty to claim that there's been a breach. You've got the sort of another kind of category which a lot of the European Union member states have adopted, which tends to also not give rise to any kind of right. So just by way of example, just give you one example, is Germany-China BIT, which says that each contracting party shall encourage investors of the other party to make investments in its territory. Well, okay, you can encourage that, but that's not a very hard obligation. And also to admit such investments in accordance with its laws and regulations. And so there you have it, the clause that allows the state to rely on the national security law, or whatever it is that prevents that investment from being admitted. Then sort of in the final category, you've got the treaties which do allow an investor a right to have their investment admitted into a state. And I'll give you an example there as well. The US model BIT says that each party shall accord to investors of the other party treatment that's no less favorable than it accords in like circumstances to its own investors. So, sorry, with respect to the establishment of an investment. So in that case, you're using the national treatment obligation that's in the treaty to actually, say, well, there's been a breach of treaty here because you've relied on a law that you haven't applied fairly because I'm from X country or whatever it is. So I think those are the sort of interesting questions that might arise as a result of these laws.
But the intersection is still between domestic and international, isn't it? You've got something like the UK Act, which presumably, if you want to challenge a blocking or a divestment order, you've got to go through the national courts, even if the investment itself says something different. How do you get away from this possible disjuncture between the administrative law aspects and then the international treaty investment aspects?
Precisely what you've said is what Letter One has done in the UK case. So like I said earlier, they've challenged it in the High Court, and then they're going to, but they've been to the Court of Appeal, and then they're going to go up to the Supreme Court. But of course, if you are going to claim that there has been a breach of the FET standard, fair and equitable treatment standard in any treaty, and you're going to need to try to show that you have exhausted all of the local remedies before you say, well, look, I was denied justice. This is not right. And I think, that's probably going to be something that, claimants or potential claimants in these situations will have to consider. There is a dispute, as there always is, with all of the standards of protection as to whether fair and equitable treatment can go any way beyond, in the judicial context, denial of justice. But if you're taking the sort of stricter interpretation, and you do, for judicial misconduct, you need to show that there has been this sort of full application all the way up to the highest authority, so that the judicial system has the chance to correct itself properly. So I think that's probably the what investors will have to do, potential investors will have to do.
But these are new areas. We haven't got a lot of international arbitration jurisprudence on how they will look at these orders made from domestic courts in relation to the investments as yet.
Yeah, I mean, that's correct. I think, well, you can always borrow from existing case law on issues that sort of parallel or similar, borrow theories, and lots of the sort of doctrine is established, has not been applied to some of these situations that are quite new. I mean, another good example of this kind of new development that's going to have to happen is in the context of sanctions. I mean, there's a whole wave of sanctions cases at the moment, and not many decisions have been made yet. This is not so distinct from what we were talking about earlier with FDI screening, but where you have sanctions imposed by a host state, which would impact the acquired business in the M&A context, for example, an asset freeze, or like letter one, a divestment order, or any kind of sort of ownership restriction. And obviously we have the Russia situation, and a lot of that arises after 2022. It's only 2026. There hasn't been that much time, and everyone knows how long investment treaty cases take to be resolved to get to an award. But all of these issues, which there's quite a few cases now, I think at least 15 cases that are related to sanctions, not just against Russian parties, but more broadly, have been filed, particularly by companies linked to sanctioned Russian individuals, against Ukraine for starters, because of course Ukraine is heavily involved, but also other countries who have been implementing sanctions regimes, their own sanctions regimes, or third-party sanctions regimes such as the EU. So I think that's a whole new kind of area of law that's coming to be developed as these cases continue. And I think really, as I said earlier, what we will be looking at is established doctrine on some of these issues. How do you apply national treatment? How do you apply FET in certain cases? And it's just sort of bringing it across to the sanctions and other FDI blocking types of disputes.
We seem to have sort of jumped into the sort of post transactional phase. Maybe we could sort of go back a little bit and discuss how you actually get there to start with in the transactional phase. It's apocryphally said of all big M&A contracts and others, the dispute settlement provisions in them are always the last thing to be dealt with, and are just dealt with in a very haphazard way, which is why you get such appalling dispute provisions in some arbitrations. Now, that may have happened in the past, but I'm pretty sure that doesn't happen now, does it? So what in the big M&A cases that you've been involved in, a lot of time is spent presumably on the dispute provisions.
I've seen some pretty pathological clauses. It does depend on who is advising these parties at the time that they're concluding these transactions, and how quickly are these transactions being concluded? I think, the kinds of cases that we do here at Corner Manual, which are in the kind of hundreds of millions to $1 billion range, where the companies that are involved are resourceful and they have resources, you don't tend so much to find too many troubles with the actual kind of way in which the clause is described. There's a seat, there are rules, the rules exist. They're not just, random made up rules, which I've seen before. And it's easy enough, I guess, not to have an actually pathological clause, which just doesn't work. But I think the thing that's more important in a way is understanding what exactly it is that you are trying to cater for, what litigation risk you're catering for when you're structuring your DR clauses, how many contracts are involved, are there parallel contracts, are we making sure that it's consistent here, will we want a different arbitration tribunal in one proceeding so that we have a second bite at the cherry, another chance to win this case, or another chance to defend it. Are we making sure that there's consolidation across these multiple contracts, if there are multiple contracts involved, because invariably there always are, if that's what we want? If we don't want consolidation, then are we making sure there are ways to ensure that we can challenge the arbitrator who's been appointed in across both disputes? So all these types of issues, which I think are sort of more important questions now, rather than the kind of straightforward, well, this is a pathological arbitration clause. It's more about looking holistically at what it is that you're seeking to address, and how you're sort of targeting those risks.
And what type of breaches are you thinking of that are involved at a sort of pre-transfer stage?
Yeah, I mean, so I guess kind of before an asset is actually transferred, you might have, your standard measures, regulation, administrative, court proceedings, taxation, all these kinds of things that have happened to the investment. And when you're sort of making that acquisition, you're kind of acquiring that investment with the benefit of all of these things that potentially occurred in connection with this investment. There's a separate question, obviously, of whether or not you, as the transferee, are able to bring a claim in connection with what's happened to that investment, which I think is a really interesting question that we can talk about a bit. But I think those are sort of the kind of interesting academic questions, and currently slightly theoretical, but no doubt going to become more and more addressed in practice. But we've talked obviously about breaches or potential breaches which occur at the time of the actual the actual transaction, so FDI screening blocks and things like that. And then of course there's a whole host of potential post-closing issues as well, which are slightly easier to deal with, because if you're the investor and you have these breaches arising after the entry has been made, you're pretty safe in terms of jurisdiction when it comes to actually bringing a claim. But when we're talking about things that have happened to the investment before you've made the investment, the question really is whether those claims can port with you, and you can take them with you and bring your claims after you've made your acquisition.
And what are the issues in relation to that sort of problem?
Yeah, so I mean, on that, there's a few different issues. So I guess the main thing always is, does the tribunal have jurisdiction to determine this claim? And that answer to that is, threefold: ratione personae, materiae temporis, is it the right person? Is the subject matter, and temporal jurisdiction as well. So that's the starting point for everything. And then kind of everything flows from there. Now, the International Law Commission's draft articles on state responsibility are also quite important, because they provide, and this is customary law, that states can't be in breach of obligations unless they're bound at the time that the act occurs. So this is sort of going towards the ratione temporis issue, which is that you can't, as an investor, claim to be protected under a treaty if the breach occurred or if the alleged breach, which we call it an act or a measure, occurred before you became a protected investor. So I think, look, let's give some examples to this. So if you acquire an asset, for example, in a country, and that asset's been the subject of some measures of state, which could be considered to be breaches of treaty, and that asset itself, so claimant incorporated in the host state, but controlled by a foreign investor, could bring a claim because of this foreign control. Would the change in ownership actually pose a problem, assuming that there's still relevant foreign control? So you still have the relevant nationality and therefore in ratione personae nexus. If the claimant is the actual entity that's incorporated in the host state, does that sort of just change of hands upstream actually affect the claim? I would suggest potentially not. Now, it's a very different situation if the claimant was the investor, the claimant was the shareholder of the asset, the company that's incorporated in the host state, and not the claimant wasn't actually the company itself. So I think there's a very big distinction there. And you have to go through all of the hurdles of jurisdiction again, including in particular this one about the time at which the obligation was in effect and therefore was breached.
This is part and parcel of what's become a little bit more frequent, which is reorganizing a company or organizing a company so that part of it ends up with a particular nationality, so that it can then access the treaty protections under a particular investment treaty, isn't it? And that there's been some jurisprudence in relation to whether or not that should be accepted and what are the rules on acceptance. And you have some jurisprudence saying, well, it's an abuse of right or an abuse of process, and then you've had others saying, well, it's there's a freedom of arbitration, a freedom of organization, and even intending to use a change of nationality in order to be able to access an investment treaty protection shouldn't be something that's prohibited. Have you got any views on that?
Yeah, I mean, I think that question is one that's been explored quite widely, unlike some of the other topics we were talking about earlier. That specific issue has been explored quite widely in the literature and in the jurisprudence. Companies have been restructuring and trying to obtain the benefit of treaty protection for some time now. I think there's a more interesting question as to whether that means that whether or not there is a BIT, a potential treaty protection, whether that actually impacts the way in which investors make decisions as whether they invest in a country, because it's typically been kind of empirically understood that investment is made without any regard to whether or not treaty protections are in place. You invest in a country which might be of certain risk, political instability, whatever it is, and you kind of accept those risks when you go in, and you don't consider whether the treaty protection is there. So you factor it into the price of your investment. But anyway, I'm digressing slightly. I think it's generally quite well accepted. There's a sort of broad consensus that any corporate restructuring done before the occurrence of a dispute is acceptable and fine. Of course, once a dispute has started, there are very legitimate reasons why tribunals have said that that's an abusive process and not permissible. But as long as you sort of, when you are looking at, how you structure your investments, considering which treaties are enforced in the country, it's perfectly sensible.
And when we, again, sort of moving on again to the post-transactional world, what sort of issues, what sort of local content requirements, can are used or considered to be breaches of treaty standards in these issues, in these cases?
Yeah, local content's an interesting one, I think, just because there's been this kind of recent discussion and kind of wave of resource nationalism, so termed resource nationalism type claims, particularly in sub-Saharan Africa, where I do a lot of work. So, local content isn't really a kind of defined term, I would
Can you
say, but
explain that for people who don't necessarily know what that is,
yeah, I mean, local content really sort of
or
means
resource nationalism?
oh, resource nationalism. Yeah, sure. It's the idea that countries are taking back control. I mean, some people call it sort of economic sovereignty, taking back control of their own resources, um, in order to bolster their own economies, give back to their own people. And sometimes local content commitments are part and parcel of that. When I say local content doesn't really have a sort of defined meaning, the general concept is about sustainable development for the local economy and development of skills for local workforce, et cetera, et cetera. So, how you implement it is this kind of key thing. And with these sort of resource nationalism, kind of, it's not quite the same, but it could be considered kind of, desire to ensure that what the country is producing is going back to the people who live there. So I think, what
But another side of the coin of that is sort of modern M&A and investment contracts have to have regard to a much wider field of operation, don't they? These days, they have to have regard to ESG matters. They have to have regard to social, whatever, social choice, social license, or whatever. These are all part and parcel of the consequences of resource nationalism and economic sovereignty. But so that if you put that into the contract to start with, then of course you're going to have to accept the obligations that you've got. But the issue is how does it impact those contracts that are older, which don't have anything specifically in them?
Yeah, so I mean, what you're talking about is very interesting as well, because you're talking about contracts. And of course, there is sort of like a parallel regime here because you have the treaty claims, and then you might have contract claims. And the contract might say one thing, and the treaty might, well, the treaty typically doesn't tend to say anything about the contract, save for this issue of the umbrella clause, but that's probably a discussion for another webinar. On this idea of kind of social license, which I think you mentioned, it's very interesting because the Bear Creek and Peru case is a very good example of how a state attempted to revoke a permission given to Bear Creek Mining, a mining company, which was to develop a silver mine, and essentially the permit was issued, but the local community was very adverse to the work that was being done. And what happened after the newly elected government came in this was in around 2011, is basically trying to deal with the social unrest that had sort of come about since this permit had been granted, was they revoked the decree which had granted permission to carry out the mining project. So Bear Creek then filed, of course, an investment treaty arbitration under the Canada-Peru Free Trade Agreement. And the tribunal in that case found in Bear Creek's favor. So Peru had a whole host of arguments about why it shouldn't be liable, including that it had the sort of the doctrine of police powers, sort of justifying sort of revocation of the mining rights was for the purposes of public security. As I mentioned, it was part of social unrest, but the tribunal rejected that, and essentially, found in favor of Bear Creek on this issue. So there is, I think, as you mentioned earlier, you might have a contract which requires you might have a contract with a state-owned entity or with a licensing body, which requires you to do certain things in order to involve the local community, ESG, etc. Query to what extent the obligations in that contract will have any impact on the treaty obligations that the state is held to by a tribunal. So it's an interesting question. There's sort of like parallel tracks.
Mm. But this is, the whole thing that we're talking about really is the what you've called the intersection, and it's parallel tracks or forks in the road when you can go one way or you can go the other, and the issue is, how does that relate? I was, in old treaties, you would find an attempt to concretize the regime so that the state couldn't gerrymander it. You'd find a stabilization clause. But I think they're a bit out of favor these days, aren't they, stabilization clauses?
Quite. Yeah, I mean, again, these are some of the sort of more historic cases, I would say, the ones where and the issue again, and I think, as I mentioned, of umbrella clauses and whether you can elevate a stabilization clause in an underlying contract into an obligation that's owed by the state by going through what's called a sort of observance of obligations clause in the treaty. And that kind of doctrinal split between the various authorities has sort of never been resolved. I mean, one of the good things about investment treaty arbitration is no matter who you're representing, be it state or investor, you will invariably find a decision which supports your position, because there's so much there's so many different views about what's right, even with some of these what seem to be very well litigated issues. But anyway, I think the other really interesting question there is, whether a state can even, does a state have the power to do this and to sort of fetter its own discretion to regulate in the first place? Which, if you draw parallels with, common law principles of judicial authorities not being able to, executive authorities not being able to fetter their own discretions. So I think, look, it's just one of these topics that's just not really been, authoritatively dealt with, and one which may well never be, given these clauses are kind of on the, sort of slowly disappearing and may well not be litigated so much in the future. But yeah, it is a very kind of interesting area of this intersection between the contract and the treaty.
But the treaty, there is quite a lot of discussion, isn't there, about the investment treaty regime generally at the moment, and calls for changes in it, which are based upon the way in which it's impacted states and their investments in the past. So there is a movement to change the investment treaty regime, I think, isn't there, for the future?
Yeah, I mean, I feel like people have been saying this for many, many years, and not so much has really concretely happened. I mean, there's certainly a trend towards, when newer treaties are concluded, they do tend to be a lot more restrictive than the old sort of generation of treaties we've seen. There's certainly, many, many more terminations than there are signatures of new treaties. We know that, for example, all of the intra-EU BITs and sort of ECT withdrawals, lots of pulling out there, and generally a trend of terminating these sort of older, more expansive investment treaties. And then there's also the rise of these sort of multilateral treaties, which have far more restrictive ISDS clauses than their predecessors. So NAFTA obviously has been replaced by that US Mexico-Canada agreement, which was very restrictive ISDS. And then the TPP, the Trans-Pacific Partnership, which was in negotiation for some time, is now known as, I think it's called the Comprehensive Progressive Pacific Partnership. And there are some very significant limitations to the scope of ISDS in that sort of free trade agreement. And I think even in that partnership, a government can actually issue an interpretation that would bind a tribunal, which is obviously not something that's done generally in across the investment treaties. But I think, look, all that to say, it's an interesting time, because as investment treaty arbitration starts to fall out of favor, and not just politically, but also there is a growing and rising kind of public perception against this this form of dispute resolution. But and not just investment treaty, but arbitration which impacts state interests in general. So you don't necessarily have to be talking about treaties, but like we were talking about before, contracts, which contracts concluded with states which provide for arbitrations. The same kind of issues as public perception of secret tribunals and a lack of transparency, and haven't done enough to allow amicus submissions, and it's all just a bit too unfair for all of these states. With you have to basically pay out of their budgets, out of their tax money. At the same time as all of this is happening, it does seem to be the case that the risks politically are continuing to develop. So I think, we were talking earlier about this sort of wave of resource nationalism across sub-Saharan Africa. ICSID's actually, the 2025 data, which was published a few months ago by ICSID, shows that the highest percentage of cases have respondents from sub-Saharan Africa. So you've got this sort of, that trend in the Sahel states, combined with the fact that mining and critical mineral disputes are also, as we move towards the energy transition, are also, largely from African jurisdictions, because that's where the critical minerals are. So I think, look, all that to say, how would this impact, your M&A transactions? We were talking earlier about whether or not there is actually a link between ISDS and investment flows. I think it's not clear that treaties are the thing that have a meaningful impact on an investor's sort of perception of risk or its investment decisions in general, really. So I think there is probably a bit of an existential question about how this institution of investment treaty arbitration, or state sovereign arbitration, is going to be dealt with in the coming years.
I personally think that a lot of states have only recently woken up to the fact of investment state arbitration. That a lot of them, my main experience is in the Middle East, but I've been involved in a number of the big investment arbitrations, some of the more recent ICSID arbitrations, and it seems to me that a lot of these states were so desperate in the 70s and 80s and 90s to get foreign investment that they willingly signed into a lot of these investment treaties, not really realizing what they were doing, and not really realizing the impact that what they did in the future, and the curtailment of the way they operated in relation to these investments might be something that could then be taken to an investment tribunal as a breach of treaty. And I think they've only in the last 10 years or so woken up to the fact that they had allowed this to happen, and they weren't very clear at the time of the investment that that's what they were doing.
Yeah, it's interesting, isn't it? Because it is a very calculated decision whether you do launch a treaty claim, particularly when you still have other investments in the country, in the host state, because it's a very strong signal. And so, I don't think that these types of claims are commenced lightly, because it does tend to destroy the value of your relationship with the state, with the existing government, and like I say, if you have other assets in the country that are not affected by whatever measures are at issue, you're taking a risk with respect to those as well. I mean, of course, there's totally different situation if you're just a sort of sole investment or exiting or no intention to continue in the region. And then at that point, you sort of think, well, let me just try and monetize this huge risk here that I've exposed myself to. But I think, look, one thing that's interesting what you say is, one of the things that I've seen recently is the idea that when you terminate an investment treaty, because like you say, maybe you've woken up to the fact that they're here and you don't want it anymore, can you actually effectively terminate the sunset clauses? I'm not sure that is something that has been, there's any jurisprudence on that particular point, but just for the benefit of everyone, treaties contain these sunset clauses, which basically say that in the event of termination, investments which have been made will be still protected for the next 10 years or 20 years or 15 years, whatever the sunset provision is, so that on termination you're not sort of immediately deprived of any protection. But some states have been deliberately, expressly terminating the sunset clause too. So I think there's an interesting question there as to whether or not that is effective.
Yeah, well, the whole, as you say, intersection between M&A and international arbitration is giving rise to lots of innovative questions. Another one, which you just mentioned, is monetization. This has become quite a common matter in relation to court cases and domestic arbitration awards, but it has recently taken off in relation to international arbitration awards, and also in investment arbitration awards. But there has been a certain amount of controversy as to whether it should apply in certain investment arbitration contexts. Do you want to tell us something about that?
Yeah, I think that this has quite had the investment arbitration community up in arms, as the suggestion that it's not possible, to monetize your exit award in the easiest way possible, which is basically just an assignment. It's quite a devastating concept to think that all of a sudden this market is no longer open, and that sort of has a ripple-on effect.
And how's that come about? Can you tell us how that's come about?
Yeah, sure. To all of the relevant players in the market. So yeah, basically historically, there's never, I don't think there has been a decision which has decided that it's not possible to assign an investment treaty award. As far as I'm aware, that the only decisions on this issue have been in favor of it. I think there was one back in 2012 in the US. Where the Southern District Court of New York held that you could enforce, an assignee could enforce an ICSID award. Now, what's happened very recently, so towards the end of last year here in the UK, a company called Opera Fund, which had an investment treaty award against Spain for various breaches of the Energy Charter Treaty, registered this award in England, and then subsequently assigned the award to a company called Blasket Renewable Investments. Now, I say it assigned it, well, it purported to assign it, because what then happened is Blasket asked to be substituted as a claimant in the enforcement proceedings. And the High Court there, and it is on appeal, this decision is on appeal, the High Court found that ICSID convention awards here in the UK under English law are not assignable. And he based his decision on sort of the construction of the ICSID convention and Article 54, which refers to a party who is seeking recognition or enforcement, and the judge there interpreted that provision as meaning just a party to the arbitration rather than just a party. And he also held that you couldn't rely on the fact that you had registered the award, and that created a sort of new right that you could assign. So the sort of separate to the actual rights under the award, the sort of registration of the award wasn't a separate assignable right. Now, what's interesting, of course, when you have a when you have a treaty award or any kind of arbitration award, you don't just enforce it in one jurisdiction. You take it to multiple jurisdictions for enforcement. And the UK was only one of other jurisdictions that Opera Fund had, and then Blasket had sought to enforce it. And so what had happened in Australia prior to the UK's decision was that Blasket had been able to enforce successfely in Australia, had been able to substitute itself, in the enforcement proceedings.
Exactly opposite result.
Yeah, and it's precisely the total opposite result was reached. But the court did, in England, the court did consider whether there was an issue of estoppel there, and it found that there wasn't. So it's
they're both under appeal, I think.
Yes, exactly. So they're under appeal. I think the UK decision is an anomaly in the sort of jurisprudence that we have on this issue to date, and so it just remains to be seen what happens next. And how the international arbitration market, or the market for these awards, how it's going to develop in response to these decisions. I mean, one thing for sure is that you would expect it to slow down a little bit, at least pending any final decision of the UK courts. At the moment, there seems to be a hell of a lot of risk if you take a decision to take an assignment of an award, and in terms of what's next, like what's the future here, if you are in the market for a secondary market for claims, for investment treaty claims, you're going to have to restructure them if Opera Fund is upheld in ways that are potentially a lot more complex and less attractive. So yeah, it's a very interesting decision, to say the least.
Watch this space. Hafsa, we're coming up to 3 minutes to 7. It's been a wonderful discussion from my point of view, and I hope that the people who have been listening have enjoyed it. I don't know if anyone has any final question or something they want to say in the last few minutes. If not, then someone, Mark Wasunda. Yes, Mark.
Thank you so much, Ian. And I just have one final quick question. And thank you, Hafsa, for that very, very informative and educative discussion you've just had. I just had a quick question to pick up on something you said earlier within your discussion with Ian, as it relates to cross-border merger and acquisitions, and specifically their contracts and the dispute resolution clauses. So in your discussion on seats, I just wanted to find out from your experience, obviously, as a partner at Quinn Emanuel's, having to do with a number of these M&A contracts, do you find that the seats chosen by the parties still seem to be, the most preferred seats? If I go by the Queen Mary's survey, this London, Hong Kong, Singapore, etc. And because I research on Africa, and you said you also, have a strong research portfolio and work portfolio as it relates to sub-Saharan Africa, do some of these contracts include seats within Africa, or do they also include some of their centers in Africa? And if not, do you have perhaps anything you've noted from within your practice that could sort of increase the use of African seats being chosen as a neutral venue in some of these global M&A contracts? Thank you so much.
Mark. Thank you.
Thanks, Mark. Absolutely. It's a really good question, and it's a interesting one. I mean, the majority of the disputes that I've done, not all of them, but the majority have involved the traditional sort of London, Paris, DC arbitration seats, and your standard sort of LCIA, UNCITRAL, or ICC rules. I have done some arbitrations which have been seated in Nigeria, and have involved the rules of the commercial, international, regional, whatever the long name for the commercial arbitration institution is in Nigeria. What I have tended to find is that in cases where you have truly multinationals, investing in country, it's very unlikely that they'll be willing to agree to a seat with supervisory jurisdiction of the courts of Nigeria or Kenya or wherever it is that the investment's being made. And they would much prefer to have a totally neutral forum, neutral in the sense that neither party is affiliated with the jurisdiction, or again, question of bargaining power, who, in these cases, as it always tends to be, depends on who has the stronger position there. So I think in terms of encouraging Africa seats, you tend to sort of see that more often with parties who are internal to Africa. So you have perhaps cross-border, and of course there's the Africa becoming of more and more importance, although there's no ISDS provision that's been agreed there yet. But if you have a cross-border within the African continent, you might have a neutral African seat as a sort of compromise for parties that are in country. The case that I did, which involved a Nigeria seat, did actually involve a multinational company, sort of with headquarters in India, headquartered in India, but with operations that were global. And they did agree to a Nigeria seat and Nigeria institutional rules, but they did regret it in the sense that the local courts, which had supervisory jurisdiction, then proceeded to take a number of steps that the client I was advising considered were improper. So I think it's a combination of very much building trust in these institutions and in these systems and in the courts of the supervisory jurisdiction, supervisory courts. It's a question of building trust in those establishments, which is something that I think takes work, takes time, and also a question of just bargaining power and what's considered to be neutral.
And can I say that the same sort of applies in the Middle East, but with one caveat, which is that increasingly there's a number of common law enclaves being created in parts of the Gulf, particularly in the UAE, and these are beginning to get cases and are being applied as the seats, generally, as you say, between locals, but sometimes between locals and international firms. Generally, not so much where you have two international firms or a big complex contract with lots of parties. That's different.
Thank you.
Who is Miles?
Hi.
Have to be quick, Miles, because I'll need to wind up soon. I don't want to keep Hafsa for much longer.
No worries. Hello?
Hi, yeah, what's your question?
Oh, yes. So I was wondering, how has the trends in, resource nationalism and other political trends across Africa, how has it affected how investors look at Africa as a place to put their money into, and how has it impacted your own work?
Hey, thanks for that, Miles. I'll just be super quick on this one. As I said earlier, when Ian and I were talking, I'm not convinced yet that there is a very direct link between treaty protection, at least, and foreign direct investment. There is probably, a link between what's been going on across the Sahel states and the way in which investors perceive the risks of making investments in those countries. But it's not something that I think empirically I have knowledge of or has necessarily even been kind of empirically studied. I don't know if there's any sort of data on whether there's been an impact, but you would think that there is. I think that the only thing to counter that really is that the resources where the resources are And so it's a calculated risk that you take when you invest in countries which are undergoing these waves of change in their political structures and in their policies. And then, sorry, I can't remember what your second question was.
It was just about how it impacts your own work.
Oh, how it impacts my own work. I've not done any cases which have involved investment treaty disputes arising out of that sort of recent wave of what's happened in Africa. But what I have done are cases which have been sort of post M&A disputes, but have touched upon on these types of issues. So after you have a coup, after you have military intervention, there can be a lot of security issues in country. And while the disputes that I've been doing in that part of the world have tended to involve commercial counterparties rather than sort of state interests, there were definitely state issues that could have been raised because, for example, just one quick example in a treaty context, this wasn't the case I was actually advising on, but it's something that could have arisen from the fact pattern, is where you have the military being required to protect your mine, for example, and you have security issues because you have a coup that's recently occurred, and you have sort of rebel forces coming in and raiding your mines, or capturing kidnapping your workforce. To what extent is the government required to take concrete steps to protect you and to protect your investment? So that sort of touches on the sort of full protection and security obligations that you tend to see in investment treaties. So I think that's one area where it certainly is factually of relevance to the stuff that I'm doing, although I haven't actually litigated that specific issue.
Thank you very much.
Thank you, Hafsa. I've enjoyed immensely hearing about all the experience you've got in this fascinating area, and I hope everyone else has too. And I would love to go on discussing it further, but we must sadly call it a day there. But thank you really very, very much for encapsulating an enormous amount of information on a lot of innovatory new areas. Really, really well. Thank you very much.
Thanks very much, Ian. I enjoyed the conversation.
And for all those others, can you have a look at the chat box? I think that Amelia Onyema, our wonderful chairwoman, and director of the Institute, has put their details of upcoming webinars for the centre. Amelia, any final words?
No, just to say massive thank you to you and to Hafsa for a very engaging and rich conversation. And I hope that for those who have attended, that you've learned something and that you thoroughly enjoyed it. And Hafsa, can I say that what I thoroughly enjoyed is, I suppose, somebody who practices in this field and knows the field. You talk about it as though it's just a walk in the park, which is great because then, the way you and Ian have engaged with it, it's made it really interactive and very, very interesting. So thank you so very much for that. Ian, thank you so very much.
Pleasure. Thank you, Hafsa. You
Thanks,
made
everyone.
it a really, really great discussion. Thank you very much indeed.
Thank you. Thanks,
And
everyone.
to everyone
everyone.
else, enjoy the rest of your sweltering day.
Yeah, quite.
Bye now.